This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi, everyone. Welcome to Crime in Court with Heather. This is Trial Transcripts Exposed. We are reading through the entire Delphi trial. We are almost complete. We have just a few episodes left, actually. So we are on part 11 of the defense's case. There's going to be 13 parts of the defense's case. Then we're going to have 2 parts of rebuttal. Then we're going to have closing and then sentencing. So it's going to be we're going to wrap this up quickly. So let us get started without further ado. So, first up, we have Elizabeth, or as she goes by, Betsy Blair. She's an eyewitness. Um, who else do we have today? I just want to go through all of our people that you're going to hear on the stand. So all of our witnesses. We have Elizabeth, or Betsy Blair. She's an eyewitness who saw, remember the poofy-haired guy, the young-looking poofy-haired guy that definitely didn't look like the original sketch that was released of Bridge Guy? She actually helped composite the younger-looking uh, police sketch from that day that was released later. We are also going to hear from Dr. Stuart Grassian. He is going to talk about the effects of solitary confinement on an individual and what that can do to someone, and possibly maybe false confessions. And then we're going to talk, or we're going to hear from Dr. Eric Warren, who is a toolmarks expert, and he is going to basically debunk the toolmarking methodology that they used in this case. So, without further ado, sorry, I'm just adjusting here. My hip is killing me. So I have like hip issues, but I also just like out of nowhere tore a hamstring, and it's awful, and I don't recommend it anywhere. It's not fun. All right, so that's why I'm adjusting constantly with my hips. Anyways, let us get to Betsy Blair's testimony. All right, so Mr. Baldwin is going to be doing the questioning for the defense. And he says, "Good morning, Betsy." The witness says, "Good morning. I know you've done this already one time, but could you state your name and spell it for the record?" "Elizabeth Blair," and she spells it. "Thank you. Betsy, how many questions did the prosecution ask you about the car you observed at the CPS building on 2/13 when we were here earlier in this trial?" "The prosecution did not ask." "Okay. We're going to talk about that. The car that you observed, is that okay?" "Yes." "All right. First of all, before we get to that, let's kind of remind the jury how many times and approximately what times did you go to the to the trail that day? Could you remind the jury of that information?" "I went to the trail 2 times. The first time, I walked for a while and I left for about a half hour, and then I came back and walked again." "Okay. And then you came back a second time?" "Right. And then do you know approximately what time you got to the trail the second time?" "So the second time, I would have gotten to the trail about a quarter till 2. "Okay. And what time do you think that you left, roughly, the trail after going on your walk?" "I believe it was about a quarter to 2, or a quarter after 2, sorry." "Quarter after 2, give or take? Give or take a few minutes?" "Approximately." "Thank you. When you left, can you tell the jury, first of all, how many cars were in the, what we call the Mears lot? You call the niches, I think." "Yes." "How many cars were there when you left? Do you remember?" "Just mine." So Richard Allen's car was not there around 2. 2:15. He wasn't there. His car wasn't there. All right. And when you left, which route did you travel which route did you travel? "When I left the lot, I turned left onto 300 North." Okay, and what buildings, if any, do you know that you pass if you're headed left on 300 North? There's a business on the north side and there's a house on the left side, kind of at the corner where you turn, and then there's the empty government building that was there near the trail parking lot, and then there's the entrance to the Anderson grain facility. Okay. Now, that government building, what was that known by back in those days in 2017? I have no idea. Did you ever hear it called the CPS lot? Other people have called it since then. Okay. But that's you passed this, what other people would call the CPS lot? Yes. Okay, and when you passed that lot, what did you observe in terms of any vehicles? I saw one vehicle in the lot. Okay. And what, if anything, caused you to notice that vehicle in the lot? The reason I remembered it is because it was not parked how other people park when they go to the trail to walk. It was parked near the empty building and it was turned around so that the front was towards the county road and the back was towards the new highway. This is backed in their spot. Okay. Kind of like somebody had backed in for maybe a quick getaway or something, or just to get away a little bit so that they don't have to back up. It was backed in. Backed in. Okay. And what else, if anything, did you notice about that vehicle that stood out? Just the overall shape of it, and it looked to me like it had sharp angles. It looked like a four-door sedan. Okay. Did it remind you of any vehicles that you have seen in your time on this earth? I like that question. Have you seen in your time on this earth? Yes. After I thought about it later, it reminded me of a car that my father had had years ago that was a 1965 Ford Comet. This is an old classic car the body looks nothing like what we would recognize as a modern car today. So it stood out to her for sure. What color, if any, do you remember that car being? I don't really remember the color, but I remember talking about what it wasn't, which it wasn't a bright color, I believe. I said it wasn't red, it wasn't yellow, but I didn't really know what color it was. Did you also say that it was not black? I don't recall that. Would it help refresh your recollection if I provided you a transcript of a prior statement from April of 2019? Yes. Thank you. Judge, may I approach? You may, says the court. I'm handing you a statement from April the 2nd, 2019, and I'd ask you to turn to page 7 at the bottom. I think it's line 25 particularly. Ms. Diener says, which statement are you referring to, Mr. Baldwin? Mr. Baldwin says, April the 12th, 2019. Tell me when you're done reading or reviewing that, Betsy. Ready? Okay. Does that refresh your recollection as to whether or not you said that that car was black? So in 2019, when I was speaking with the investigators, I said it was a nondescript color. Ms. Diener says, Judge, may I object? Proper use of the transcript would be to have her read it, see if it refreshes her recollection, and then take it back, and he has not done so. Correct, says the court. Thank you. Does this refresh your recollection as to whether you said the color of the car was black or not? In 2019, I said it could have been black. You said, I'm sorry? In 2019, at that time, I said it could have been black. It could have been? That it could not have been. Oh, could not have been. Okay, thank you. All right. Did that car look like a hatchback to you? Like a hatchback Ford? I think you had a Ford Focus, a black Ford Focus. So all of these things that she's saying is basically throwing out the state's descriptions or the witnesses that are making the witnesses less credible because this is what she remembers. So she remembers an old classic 1965 Ford Comet, which was not black. Could it have been a hatchback? I did not see the back of the car. I saw the side of it, but it looked like a four-door sedan to me at the time. Did you ever draw for law enforcement the profile of the vehicle that you saw? I did. Judge, may I approach? The court says you may. I'm handing you defendant's exhibit LLL and ask you to look at that for a second. Tell me when you're done. Mr. Baldwin, may I have a copy? Says Miss Diener. Oh, sorry, he says. Ms. Diener says thank you. The witness says, I'm done. Does that document fairly and accurately depict what you drew for the police? This is my drawing, yes. As to and you describe for the jury what it is? It's a basic outline of the top of the car. Move to admit defendant LLL. No objection, says Ms. Diener. The court says, all right, without objection, LLL is admitted. Mr. Baldwin says, move to publish. The court says you may, and it is. The court says you may proceed. Mr. Baldwin says, thank you, Judge. I have no other questions. So they didn't even ask her about the car on her direct examination when she testified for the state. And she didn't see Richard Allen. So she's actually a really good witness for the defense if the jury was paying attention to what she was saying, but I don't think they did, or the fix was in already. I don't know. It's possible that the jury was. I definitely believe that the prosecution tried to hide things from the jury, including the judge too. I think she tried to hide all the Odin stuff and the third-party suspects and the nexus that actually was gigantic, but whatever. Let's move on. So, cross-examination of Elizabeth Blair or Betsy Blair by Ms. Diener. Ms. Blair, do you recall that you also spoke with police in 2017 on February 17th? Yes, I did. And I provided you with copies of all your statements? Yeah, long before trial. Is that correct? Correct. And so you've had those to look at? Yes. Do you remember on February 17th of 2017 telling officers that you noticed the car because it was closer to the building, backed in slightly at an angle, you found it odd that they would park there, and it was not a bright color, nondescript sedan, not new, not real shiny, nothing really stood out? Yes. And after some discovery, did I again contact you to tell you that another witness said that they saw an older model vehicle pulled off the road between the corner, the sharp left-hand turn, and the CPS building? Do you recall that? Yes. And I told you it was an older model vehicle that might be similar to the one that you described. Judge, I'm objecting. Yes, says the witness. Mr. Baldwin says, to the testimony, is she a witness or is she an attorney on this case? Mr. Diener says, Judge, I shared with the witness conflicting testimony to ask her if it changed her recollection. That's the purpose of the question. Overruled. But she's absolutely putting herself in as a witness because the question was, it started when, and I provided you with copies of your statements. So are you prepping her? Like what? Uh, she's just a witness, right? Or are you protecting her somehow? I don't know. She's basically, is she a witness or an attorney? It was overruled. Okay, so Mr. Baldwin says, well, Judge, do I have an opportunity to put the prosecutor on the stand to ask her what about that conversation? The court said, certainly. And then Ms. Diener says, may I continue, Judge? Yes, you may. God, they're so annoying. Ms. Blair says, I asked you if it would change your recollection about the vehicle that you saw. Is that correct? You did. And did it have any impact on your memory of what happened on February 13th of 2017? I feel certain that that's the shape of the car I saw at that time. And you feel certain that it was at the CPS building? I couldn't quite hear that. It's okay. You feel certain that it was at the CPS building, correct? Yes, it was absolutely at the building. Okay. And how was your vision back in 2017? Did you have any corrective lenses or anything like that? I wear contact lenses and I have them on all the time. Terrific. No other questions. The court says, Mr. Baldwin. Mr. Baldwin says, no, thank you, Judge. Court says, does anybody on the jury have any questions for Ms. Blair? Counsel approach. So we have a couple questions for her. In a sidebar conference, the court reads to the attorneys, is it possible the car parked in the CPS lot belonged to someone inside of the building working? Ms. Diener says, I think she'll describe it as abandoned, but yeah. Court says, okay. Ms. Diener says, who knows? The court says, do you know if anyone checked to see if it belonged to an employee? Ms. Diener says, I'm fine with that. Mr. Baldwin says, yeah, thank you. Sidebar concluded. Now this is in front of the jury. The court asks, all right, Ms. Blair, is it possible the car parked in the CPS lot belonged to someone inside of the building working? The building looked abandoned, and I believed that it had been abandoned for some time. Okay, Mr. Baldwin? No questions, Judge. Ms. Diener says, also no questions. Next question is, do you know if anyone checked to see if it belonged to an employee? I don't know if anyone did. Mr. Baldwin? No questions, Judge. Thank you. Ms. Diener? No questions. The court says, all right. Thank you, Ms. Blair. You may step down. You may call your next witness. So Dr. Stuart Grassian is called by Mr. Rosie, who will be doing the questioning. He's sworn in. Mr. Rosie says, may I? And the court says, you may. All right. Doctor, go ahead and tell the jury your name. My name's Dr. Stuart Grassian. And could you spell that? Say it a little louder, and he does. Okay, right outside of, sorry. All right, and where do you live generally? Right outside of Boston in the Chestnut Hill section. And tell the jury, what do you do for a living? I'm a psychiatrist. All right, and just kind of generally, what's your educational background? Well, my undergraduate degree is from Harvard University. I have a master's degree in sociology from Brandeis. My MD degree is from New York University Medical Center, where I also did an internship in medicine and then went on to Harvard Medical School, the Beth Israel Hospital in Boston, where I did a residency in adult and adolescent psychiatry, became board certified in psychiatry in 1979, and also have a JD degree that I got in 1986 at night school. He's well educated. And the JD meaning you have basically a law degree. I have a law degree, yeah. Many, many years ago, right? Many years ago. Okay. All right. And do you also teach or have you taught this kind of on the academic side or something? Yes, I mean, I was on the chemical facility. I'm sorry, the clinical facility. I was on the clinical facility at Harvard Medical School for about 25 years, and I had to stop doing that because of some significant family medical issues. But I still give lectures and seminars and such from time to time. Okay. And then just real quickly, in terms of, I don't want to get into all of this, but just in terms of like board certifications, is there some kind of board that psychiatrists are on that's, important to your profession or required? Yeah, well, the official board that recognizes the specialty certification is the American Board of Psychiatry and Neurology, and I've been board certified since 1979. Thank you. You're going to have to keep speaking up because you're kind of trailing off. Sorry, I don't think moving that close is going to help. He says no. You've got to speak up. And so, are you in good standing, so to speak, with the board? Yes, of your profession. Yeah, fine, yes. Okay, all right. And in the course of how long have you been a psychiatrist now? A long time. I completed my residency in 1977. Okay. And during the course of your career dating back to 77, has there been any particular area of psychiatry that you've taken a special interest in? Well, yes. As you're aware, I've become kind of a well-known expert regarding the psychiatric effects of solitary confinement. I also have done some research and work regarding memory of traumatic events, and false memories. Okay. And have you testified in courts like this one around the country over the course of your career? Yes, quite a number of times. Okay. Can you just tell the jury, just give them some context as to why you would be called into a courtroom, what kind of things you've talked to jurors about over the course of your career? Oh God, there's such a wide variety. Often it has to do with things like the psychiatric effects of a person having been in solitary. Sometimes people commit bad acts, crazy acts, and it's important to understand the mental state the person was in at the time of the act. People have been in solitary and have suffered terribly and for no good reason. The courts have found, malicious prosecution and recently awarded quite significant damages in the millions for that. Did you testify? I mean, are you one of the guys that only testified for one side or the other, or how does that kind of work in your industry? I my testimony regarding solitary confinement is basically always about the psychiatric effects of solitary confinement, but that can take all kinds of different forms. Like, for example, one time I was hired by the federal defender for a case involving an accused terrorist, the Millennium Bomber, and my work really was very much in cooperation with a very senior FBI guy who's involved with behavior analysis. It was basically the way that they were treating him in solitary. It was because he had been cooperating and helping the government, and then they started treating him harshly with solitary, and he just shut up, and we were able to turn that around for a while. So you kind of work on both sides of the aisle. Yeah. Last question I'm going to ask you about your background is, have you spent time studying larger groups of people as it relates to solitary confinement, like prison studies or anything of that nature? Well, I've been involved in both individual and also class action lawsuits involving solitary confinement and, have been involved in testifying in legislatures and stuff. Altogether, I've probably evaluated, well, several hundred people who were in solitary and had been in solitary a number of hundreds. May I approach? Says Mr. Rosie. The court says you may. I'm going to hand you what's been marked as Exhibit MMM and just take a quick look at that, if you would. Okay, that looks pretty familiar. Is that a copy of your CV or your resume, curriculum vitae? Yes, I typed it myself. Okay, and does this highlight a lot of things that we've talked about, plus others? Yes, yes. Is one of the additional sections of information on here about literature that you've published in this particular area? Yes. And you've done that on a number of occasions too. Yes. My first publication in this area was in the American Journal of Psychiatry, and it really created quite a change in things. Move to admit MMM. Ms. Diener says, no objection. And the court says, all right, without objection, MMM is admitted. Mr. Rosie says, may I publish? The court says you may, and it is. And next question. So just tell the jury what you do on a daily basis. Like, what do you do as your Monday through Friday in terms of your profession? Sure. I have a clinical practice in my home. I used to do work in hospitals as well, but I don't any longer, just in my own home. And in addition, I do get involved in forensic cases, many of which have to do with the psychiatric effects of solitary confinement involving class action lawsuits, individual lawsuits. I do work pro bono for a governmental organization in New York in which I've helped review mental health files of patients, inmates who had mental health problems to see whether they're getting adequate treatment, As I said, I give lectures at the Harvard Medical School Center on bioethics, other places as well, Harvard Law School on those particular issues. Okay, so you see patients? Yes. Okay, did there come a time when you reached out to, when I reached out to you? Again, or no, this is Rosie, sorry. This is Rosie. But he's saying, did there come a time when I reached out to you to assist in this case? For him to assist in this case. Okay, so that makes sense that he reached out and hired an expert. You did. Yeah. Just tell the jury kind of what you remember about that and what, I guess, the demand, if you will, or the request was on our part. I can't say I remember it in detail, but I understand that Mr. Allen had made some potentially or seemingly incriminating statements while he was in solitary confinement, and there was a question of whether his conditions of confinement, his mental state, may have had an important impact on the statements that he was making. Okay. And did I offer up to you information to review at some point? Yes, in order to, before we really started talking. Of course, yes. Okay. Just tell the jury what generally you recall of that information. Sure. There was Dr. Westcott's INE report. There were medical reports and other records from the jails that he was in, videos of, especially of that time when he was his most deranged, and a bunch of other records as well. Okay. I don't remember as I sit here. Maybe you could refresh my memory. Well, do you recall listening to some audio of phone calls? Oh, yes, of course, that's right. And transcripts of interviews of corrections officers who, not just corrections officers, also inmates who had been companions and had heard him make these statements and were then interviewed by investigators. Okay. And was there a general time frame that was associated with the information that I gave you? Yes, it was from, what was it? November of 2022 to April, May, a little bit of June of 2023. Okay. Did I also provide you some information earlier this year in, I think, January or February maybe, from Wabash Valley? Oh, yes. Yes, up to about February of 2020, February 2024. Yeah, of 2024, not February 24th. Sorry. I thought for a second there was February 24th. Okay. So the answer is, oh yes, yes, up to about February of 2024, I think, or March 2024. I recall that. Getting some information about Wabash Valley. Okay. And in the course of reviewing that information, was there anything that stood out to you in terms of these incriminating statements that were being made by Mr. Allen? I mean, there's no doubt that Mr. Allen was in a. Ms. Diener says, Judge, may we approach? And a sidebar is conducted here real quick. So the sidebar, Ms. Diener says, Judge, I thought we discussed that he could not discuss an opinion specifically about Mr. Allen. He could talk about the effects of solitary confinement. He can talk about the possible results of solitary confinement, but not about Mr. Allen specifically. That's so friggin' stupid. He's an expert for the defense. Why can't he talk about Allen specifically? And he was about to say it's clear to him that Mr. Allen, and that it is his position that about Mr. Allen himself. Really? Mr. Rosie says, well, I don't know what he was about to say, honestly. I don't know that anyone can predict what he was about to say. But the court says it's troubling that you don't know what your own witness is going to say, Mr. Rosie. Well, we're not friggin' mind readers. We're attorneys. We ask questions, right? Miss Rosie says, well, I do think that I know what he was going to say. Court says, okay. And he's going to say that he heard Mr. Allen say things that was clearly not consistent with the facts in the case. He doesn't know the facts in the case, says Ms. Diener. The court says no. Mr. Rosie says, yeah, he does. He's reviewed all kinds of stuff. Ms. Diener says he can't include any police reports in that list of things that he read. Mr. Rosie says something, but we can't hear it. Why can't he include police reports? The court says, okay, well, he can't say. Mr. Rosie says, it's okay, I'm listening. The court says, no, I mean, he can't testify. He can testify to the effects of solitary confinement to the psychiatric thought process and the fact it's not healthy. But you're staying away from him testifying about Mr. Allen, what he said. If it's a confession or not, that's for a jury to determine. I understand, says Mr. Rosie. The court says, so he can educate the jury about the effects of solitary confinement, something, 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 effects of solitary confinement in general terms. Ms. Diener says, even if he knows what the charges are, he can't say that he made a statement inconsistent with the facts of the case. The court says no. Ms. Diener says he cannot say that. Mr. Rosie says I don't understand how he can't testify to something that we all know is patently false. Ms. Diener says, no, we don't all know that. The court says that's for the jury to decide. Ms. Diener says that's for the jury to decide. The court says that's for the jury to determine. Mr. Rosie says, well, the fact that the girls weren't shot is patently false, right? The court says, well, yes. So I don't know how you're going to parse those things out. Mr. Rosie says, I'm trying to get this right. I'll tell you what, I'll get the scientific stuff. Yeah, get to the science, says Ms. Diener. Fuck off, you friggin' bitch. Sorry. Mr. Rosie says, all right. Sidebar conference concluded. Does it seem like the court and the prosecution are working together? Because it does to me. At least, sort of, kind of, in this conversation, it really did. So the sidebar conference is concluded, and Rosie asks, may I continue? You may, says the court. Thank you. So, Dr. Grassian, let's talk about solitary confinement, okay? Sure. That's what you're here to talk about. Tell the jury, explain to the jury what that phrase even means in a clinical sense or in a professional sense. Well, basically, solitary confinement is the confinement of an individual in a small cell, roughly 80 or 90 square feet, with minimal opportunities for perpetual stimulation. There's very limited opportunities for any kind of meaningful social interaction and no real opportunities for occupational stimulation. So it's an enormously lonely, helpless environment and is very toxic to mental functioning. People cannot function for an extended period of time with continuing inadequate levels of stimulation. They can't maintain an adequate state of alertness, and in the worst cases, of course, in the most severe cases, they can become psychotically delirious, confused, disoriented, engaging in really regressed, bizarre kinds of behavior, like I believe folks have seen here in the videos. Objection, judge, that were presented, continues the witness. The court says sustained, because you can't get into that. Okay. When you reviewed those videos, did you find the conditions that Mr. Allen was enduring as meeting those conditions that you just associated with solitary confinement? Totally. And his judge, may I ask a preliminary question? The court says you may. Dr. Grassian, what is your familiarity with the conditions of Mr. Allen's confinement? What I read in the notes from Dr. Walla from other sources that he was basically in a small cell, very barren, had very little to do except read the Bible. Did you ever visit? Excuse me, I'm sorry. Was laying on a mattress on the floor. There was sometimes mice droppings. I've never visited the facility, no, but okay. But I visited so many that it doesn't seem, unfortunately, all that is similar from other facilities I have seen. Ms. Diener says, do you know that he's in a one-man cell? Yes. But you never visited the WCU? Not that particular facility, no. And can you distinguish between the circumstances that you learned from, say, someone like Dr. Walla versus information provided to you by another inmate? Mr. Rosie says, Judge, I'm going to object. This seems like more of a cross-examination at this point. Court says, yeah, is there a basis for this objection? Ms. Diener says, well, he said he learned it from a lot of different sources, and I'm just wondering if those would be considered reliable sources since he never visited the prison. Mr. Rosie said, they're the same sources that Officer Harshman testified that he gathered information and generated. The court says, we're not getting into comparing different witnesses back and forth. Finish your foundational questions for your objection. Ms. Diener says, okay, so Dr. Grassian, you saw video provided by the defense, is that correct? Yes. And you're familiar with what a one-man cell might look like? Is that familiar? Or is that fair? I am familiar with what the video shows itself. Okay, no other questions, Judge. Okay, says the court. May I continue? The court says you may proceed. What are the international standards for solitary confinement and who regulates that? Well, unfortunately, they're not regulated by an international body. The United Nations considers anything more than 15 days of solitary confinement to be a form of torture because of its, Judge, I'm going to object, toxic effect. Continues the witness. Ms. Diener says, I'm going to object to this line of questioning. The international standards for solitary confinement does not have any applicability to the WCU or the Indiana Department of Corrections if we could limit it to that area. Mr. Rosie says, Judge, this is opinion testimony by an expert who has laid a foundation that he has had a career in this business of solitary confinement, and the fact that there are different standards in different areas of the world has a tendency to prove that the standard that is being used here may or may not be excessive. That's the jury's determination, but the court says, okay, but he's testified there are no international standards, so I'll sustain the objection. Move on. The witness says, I may have mischaracterized. Hold on, says Mr. Rosie. The court says, hold on, sir. My testimony. Yeah, that's all right. Does the United Nations recognize solitary confinement as a phrase of art? Yes. Okay, and do they have policies and standards through the United Nations regarding solitary confinement? Okay, yes, he says. And do they have policies and standards through all of that? Did I just read the same question twice? Yes, they do. I mean, obviously, what I was trying to indicate is they have no authority to impose those on any particular jurisdiction. Okay, but the 15 days is their standard. That is their standard, and it's the standard in many jurisdictions. 15 days max. 13 months. 13 months Richard Allen was in solitary. So that's a lot more than the 15 days. Okay. So you talked about some of the symptoms that one might suffer from solitary confinement. You just started to touch on it. Would you briefly identify those for the jury? Well, in the most severe cases, people become overtly delirious. They become disoriented, confused. Their memory for events disappears very typically. In fact, when a person recovers from delirium, one of the frightening things they experience is they have no memory for what happened during the period of time that they were delirious. Their behavior regresses to a point of that's really kind of grotesque. Smearing feces, unfortunately, is one of the more common things that happens to people in delirium. But acting out sexually, being naked, smearing themselves, throwing things all over the ground and not knowing what they're doing where they are. That's about as bad as it gets, of course. In that context, of course, there are situations where people have seriously injured themselves or killed themselves. But even people who tolerated the solitary confinement better than that will find that they have difficulties with memory, with concentration, with thinking. They become hyper responsive to stimulation. They can't stand stimulation at all. They become obsessional. A lot of really awful things happen. Very high rate of taking their own lives associated with solitary confinement, roughly 7 to 9 times as great as it is in general population. You mentioned the word delirium. There was a question about that earlier in this trial. Can you just tell the jury kind of clinically what delirium is? I think you've kind of touched on that. Yeah. Well, yeah, delirium is the inability to maintain an adequate state of alertness. So the person becomes mentally confused, can't think straight, can't remember things well. When it really gets bad, it's like you have this huge fog or this thick soup in your head, and everything just floats by and nothing makes sense at all. Just a total bewilderment. What causes delirium? Well, it can be caused generally by two types of factors. One is internal factors. The internal activating system is deranged. For example, people in severe sepsis, people in severe congestive heart failure, respiratory failure, other organ system failure can develop delirium. And other things that can cause it is inadequate levels of external stimulation. So we see it in people, for example, in medical situations. Eye patched patients have developed it. Poliomyelitis patients in the past who were in iron lungs, who are sort of confined to these iron lungs, that was a major problem for them. We also have things called ICU psychosis, intensive care unit psychosis. I recently had cataract surgery. Spoke with my ophthalmologist. He's really familiar with the whole problem with eye patched patients and visually impaired patients developing hallucinations and sometimes becoming overtly confused and delirious. So it was interesting that he had had that experience as well. That's crazy that you can become that, like, just by the lack of stimulation, you can have such adverse effects. To me, that's just, it's wild. Anyways, so it could be caused by medical conditions or just external stressors or the deprivation of external stimulation, like an eye patch patient. Okay, a patient in an iron lung, they have very little in way of external stimulation. And so, well, did you get a chance to listen to phone calls that I sent you of Mr. Allen and various people? Yes, I did. Okay, and in listening to those phone calls without getting into what was said, did you see any indicators of this onset of delirium or existence? I don't want to put those words in your mouth. Ms. Diener, of course, says, Judge, I would object to him relating it to Mr. Allen's phone call specifically. He can talk about the phenomenon and how it could be brought about in his environment, but not with respect to Mr. Allen specifically. I don't understand how this witness, who is hired by Richard Allen to defend him, can't talk about Richard Allen himself. This makes no sense. I'm like irate for the defense. Why can't he specifically say, yes, I saw these signs in Richard Allen? Because it hurts the state's case? Yeah, that's why. But there's no real legal reason why he can't do it, I don't think. So, anyways, Ms. Diener says she's objecting. Mr. Rosie says, Judge, again, he said he's reviewed an INE 130 all the things. He's reviewed video, audio, transcripts, and that he's listened to the audio of these phone calls. I think he's got a proper foundation to generate an opinion about whether he sees symptoms consistent with delirium. I'm not asking him if he The court says, as long as that's how the witness limits the answer. Mr. Rosie says, okay, I can't, I appreciate that. May I continue? The court says, as long as you limit the answer, yes. Did you see symptoms consistent with this delirious state? Yes. Absolutely, yes. The inability to remember and then becoming very frightened by his inability to remember what just happened, like asking his wife. Objection, Judge, says Ms. Diener. Okay, you can't talk about what he's saying. Ms. Diener says, he's about to testify to a statement of opinion. The court says, sustained. Was there any doubt in your mind that this state of mind existed when you heard all of this? This was absolutely classic. There was no doubt in my mind. No doubt in this expert's mind about the fact that Richard Allen was showing signs of delirium at the time, on his phone calls while he was incarcerated at Westville. Next question. Okay, and let's talk about false memories, okay? Do you recognize that phrase? Yes. Tell the jury just again, clinically, what does that mean to you? Sure, in studying memory, you come to realize that many people in many circumstances develop memories that are untrue, but they experience them as being true. And I did a study with one psychologist, well, actually a few psychologists, in which we realized that a false memory, after it's reviewed and reviewed and reviewed and reviewed by the patient, by the individual, starts looking very much like a memory. So we went back and tried to understand how the memory developed, and what we saw was that false memories don't start as real memories. They start as beliefs. So people, mm, may people, I don't know, people with a false memory will say, I think I did it, or I think I saw it. And after a while, they work on it. They work on it in their mind, and visual, or, perpetual images start to develop that become memories. In fact, if you were to try to remember something that happened a long time ago, what you actually end up remembering is the last time you thought about it, the last time that you saw it. So your memory can shift over time like a game of telephone, if you're familiar with that. So that's basically what we discovered, which I talk about in my Debunked and Dissected series. We talk about eyewitness testimony in one of them, and how unreliable it is, because the last time you're remembering a memory is the last time you remembered it, and each time it could be a little bit different. It could even be a memory that you implanted yourself somehow. Some psychologically, you wanted to remember something some way, and you did, but it isn't actually a real memory. So it's possible. So when a person starts having quote unquote memory by saying, I think I remember seeing this, or I think I did this, that's not the way memories are really emerge, but that's really the way false memories emerge. And in reviewing the information in this case, did you find some hallmarks consistent with that concept? Perfectly consistent. I mean, again, very classic. Okay, that's enough. Ms. Diener says, objection, Judge. That's enough, says Rosie. Ms. Diener says he's getting into sustained evaluation of Mr. Allen, says Diener. The court says sustained. Is the answer yes or no? Yes. Mr. Rosie says, okay, I don't have any other questions. What was the last question? That he, in reviewing the information of the case, did you find hallmarks consistent with the concept of false memories in this case? And he said yes. So he believes Richard Allen was stating false memories. And then now we're going to go to cross-examination. Oh, joy, because Ms. Diener is so lovely. She's actually really annoying to me. Her and Nick. Nick is such a little weasel. She asks, Dr. Grassian, when you were just talking about the study of false memory, and you said you provide a person with something and they review it and review it and review it and it becomes a memory, what did you provide them to review? I didn't provide them anything to review. This is studies that were done by other researchers like Elizabeth Loftus. Oh, she's awesome. I might have talked about her or gone over something of hers on my channel before. She deals with false memories. For example, it's quite famous in this area. She does a huge TED talk on it about people creating false memories. Our work involved people who had long periods of time when they stated that they had no memory for sexual abuse, and then I guess memory started. May I be more specific? Mr. Rosie says, "Well, what? Uh, sorry, we're getting off on a. Can my dog sit down, please? Dog, sit down, bud. You're in the camera. Nobody wants to see your butt in the camera. You can turn around and show them your face." Here's his cute little face. He's getting big. Actually, when we had him, he was like 13 pounds. Now he's like 17 pounds. So he's growing, and he's getting tall too. Um, just hold on. Let me just readjust my mic here a little bit. All right, I think we're good now. Our work involved people who had a long period of time when they stated that they had no memory for sexual abuse, and then, well, I guess memories started. May I be more specific? Miss Rosie says, well, and the witness says, what? The question, Ms. Diener says, sorry, we're getting cut off on the court says, yeah, tangent. Mr. Rosie says, but she doesn't want to hear what he has to say. I mean, because she keeps cutting him off. Ms. Diener says, I'm trying to be very specific about my question and I'm making an effort. The court says, then narrow your question down so that he knows what it is specifically. Mr. Rosie says, thank you. The court says that you're asking him. Yeah, I'm sorry, Dr. Grassian. I just want to know what is it that the subject reviewed and reviewed and reviewed that then became a false memory was it a document? Was it a picture in the study? No, you're confused because that is not my study, our study. Our study was of people who had a long period of time of no memory for a traumatic event and then developed a memory, and some of whom ended up recanting the memory. And we tried to sort out what was the difference between these folks who ended up recanting, and clearly, in fact, in some cases, they were inevitably false because they were facts that were inconsistent with reality, and comparing that with people who seem to have recovered real memories. What we found was that people who recovered real memories, when they recovered the memory, it would be enormously perceptual, I mean, a smell, a sight, a sound, whereas the people who ended up recanting, you found that at the beginning what they talked about was a belief and then a vague perception, and that gradually over time the perception became more clear. Interesting. That's an interesting study, I think. So he takes people who couldn't remember something, then had a memory, and then later recanted that memory or retracted it and said that wasn't true. The people that had retracted their memories, they were doing it on a belief. It was like wrapped up around a belief. Whereas the people who were actually remembering their their experiences, their real memories, they were experiencing things that were your five senses, because that's usually what you're going to talk about. Well, I saw so and so, or I saw red shoes, I saw a blue car, whatever it is. You're going to immediately go to sights, sounds, smells, what you felt at the time. You're not going to say, well, I think that it was whatever, because, and then start to fill in the blank. You know what I'm saying? So there's a big difference. And I think that's a really interesting study and a really good distinction from what she's talking about, what Ms. Diener's talking about. So let me ask you about when you found the real memory, would a real memory be detailed, chronological, logical? I'm not. The real memory versus the false memory. Real memories are extremely perceptual, is what I would say. Perceptual? Right. Like they would, I'm not sure what your question. Yeah, they would include sight or insight, maybe by the person telling the story. Insight? Insight. Okay, dude, he's awake and he's playing, so everything is a play toy. Or he likes to chew on my hairbrush. I don't know why, but it's gonna get loud, so I don't want him doing that right now. We're having technical puppy difficulties at the moment. DJ, you're making my job difficult. You guys are gonna go out. Okay, I think he's settled down now. Maybe finally. I don't know. We'll see. The question was, she moved on from that weird question, and she says, are you aware of critical factors that are used in the prison setting when a decision is made to place a person in safekeeping? I'm somewhat aware of it, but I don't consider myself as an expert on prison, okay, administration. In your study of solitary confinement, do you distinguish solitary confinement for corrective or punishment purposes versus one-man cell confinement for safety? Well, what I concern myself with are the conditions of confinement. There are people, for example, who are in protective custody but are allowed to have conjoint recreation, conjoint activities with a small group of people who are safe. Okay. So, what I'm concerned about is the situation that the individual has, the conditions they experience, whatever the reason is that the administration caused the person to be in that type of confinement. But you acknowledge there's a difference between solitary confinement and a one-man cell for safekeeping to protect a person confined. Would you agree? No. It still does the same to your mind, you frickin' idiot. In terms of the psychiatric impact, it would depend on the conditions that were imposed. Okay, thank you. No other questions. Redirect. Mr. Rosie asks, regardless of how somebody is labeled, would putting them in solitary confinement impact their brain? Again, if the conditions of confinement are the defining factor, then independent of why, what the justification was for putting them in solitary confinement, it's about the conditions they experience. I don't have anything further. Okay, Ms. Diener. Nothing further, Judge, because you can't come back from that. You can't come back from that. He says it has to do with the conditions, but pretty much no. It's the experience, it's the conditions, it's all of it. It doesn't matter why you're there. They keep trying to say, well, he was there for safety reasons. That's not an excuse. That doesn't justify putting him there for 13 months. Anyways, this case makes me irate. All right, nothing further from Ms. Diener. The court says, does anybody on the jury have any questions for Mr. Grassian? I'm sorry, Dr. Grassian. All right, well, would counsel approach? So we've got some questions here. And they go to a sidebar. The court says, observing Mr. Allen daily in the courtroom, he has not seemed to be delirious or psychotic physically. Is this related to be because he is no longer in solitary confinement? I don't think you should ask that, says Mr. Rosie. Ms. Diener says, that one leads back, Mr. Rosie says, because that's not enough facts and evidence to really. The court says, do you believe a completely normal person can become psychotic after spending 6 to 12 months in solitary confinement? That's obviously a good question, says Mr. Rosie. The court says, do you believe psychotic behavior can go back to normal behavior after being removed from solitary confinement? Yeah, that's fine, says Mr. Rosie. Those are good questions. The court says, Dr. Westcott's report states that Richard Allen functions with a cognitive ability that is 2 to 5% of his age and education, specifically impaired executive function. How would a person with this cognitive ability be affected by solitary confinement? Ms. Diener says, how? Ms. Rosie says, that's another phrase of art. The court says, how would a person who is cognitively impaired be affected by solitary confinement? Mr. Rosie says, I kind of think. Ms. Diener says, that's very specific. Mr. Rosie says, you're asking him to draw an opinion about things that you really didn't want him to testify about. The court says, what relativity does an objective personality test provide into your diagnosis? An objective personality test. Ms. Diener says he didn't talk about doing any testing. Mr. Rosie says, yeah, outside the scope. Ms. Diener says, yeah. The court says, so no, okay, so this is all no. Does someone being diagnosed with major depressive disorder with psychosis mean that any statements made cannot have any truth in them? Mr. Rosie says, I say no. I just don't, I think he's not, I wanted him to testify about some of this stuff, but I don't think that was that he was allowed to do so. So the court says no. Mr. Rosie says so. So these two then. Sidebar concluded. Now this is in front of everybody. The court asks Dr. Grassian, Doctor, do you believe psychotic behavior can go back to normal behavior after being removed from solitary confinement? Generally, the answer to that is yes. And of course, in some cases, we know that Mr. Allen had a psychotic. Objection, Judge, says Ms. Diener. No, sir, just limit it to the question, please. Okay, yeah. Wouldn't that be so confusing to the witness as to why they can't answer anything about the particular defendant that they're there, that they were hired to review their records? It's so weird that he can't even say Richard Allen's name. Um, he says, "Okay, yeah, but the answer is generally yes." And the court says, "Okay, Mr. Rosie, any follow-up?" Just 1 second. No, no follow-up. Ms. Diener, no follow-up. Do you believe a completely normal person can become psychotic after spending 6 months to a year in solitary confinement? Absolutely. I have seen it. Mr. Rosie, any follow-up? No. Ms. Diener? No follow-up. I bet you it takes less than 6 months. 6 months is a long time. It probably takes less than that. Court says, all right. Thank you, doctor. You may step down. The witness says, thank you. Mr. Rosie says, Judge, if you just give me a minute here to kind of stage, she says, okay. I'm going to get my notes. I'm just going to usher him out. The court says, okay. And then Mr. Rosie says, I call Dr. Eric Warren, Your Honor. And now we move on to the tool marks expert. And I forgot to mention, we're only going to get through his direct. So we'll stop it after his direct and we'll finish him, his cross and everything in episode defense part 12. All right, so Mr. Rosie is doing the cross again for Dr. Eric Warren. He says, all right, Dr. Warren, I'm now realizing I didn't make copies of your CV. So let's let the jury, just tell the jury what your name is. My name is Eric Warren, and he spells it. Okay, and tell the jury where you live, just generally. So I live near Memphis, Tennessee. All right, what do you do for a living? So I own my own company. It's called SEP Forensic Consultants. So SEP Forensic Consultants, where I routinely provide, as the name suggests, consulting in various areas of forensics, to include firearm and tool mark identification, as well as crime scene reconstruction and shooting incident reconstruction. Okay. And what's your highest level of education? Just tell the jury how you were educated. So I have a bachelor's degree in molecular and cellular biology with a minor in chemistry, and I have a doctorate in biochemistry and molecular biophysics, both of which are from Vanderbilt University. And in terms of your work experience, just give the jury some idea of kind of the evolution of your employment circumstances since you got out of college. So after I earned my doctorate degree, I was applied to, and hired by the Tennessee Bureau of Investigation, or the TBI. During my tenure there, I was a special agent forensic scientist. That entire time, I was assigned to the firearm and tool mark identification unit. And so part of that initial 2 years was an on-the-job training program set forth by the guidelines of the Association of Firearm and Tool Mark Examiners, which I called AFTE for short. AFTE for short. After I completed that successfully, I was signed off on independent casework where I continued to do that until I left to start my own company. In addition to that, I was assigned to the Violent Crime Response Team, or the VCRT, where I would routinely leave the laboratory and actually go respond to a scene where law enforcement agencies had a particularly violent crime scene that they needed assistance within either tracking down leads or solving that particular crime. So you work for the state of Tennessee, right? Yes, I did. And is that like you work for law enforcement? Yes, I was law enforcement. I was sworn during that entire time. Okay. And then just, well, tell the jury why you left, I guess. So, my background through my academics was all research based, looking at the effects of external things on your body and how they led to things like cancer. And so, when I transitioned to forensic science, looking at how external things, but now like bullets, how they would have effects on the inside of our body, really piqued my interest to do research. And unfortunately, when you're in a crime laboratory environment like I was, the majority of your time has to be focused on just working evidence and getting cases out the door. I missed that. The work environment wasn't conducive to be able to adopt that research approach the way I wanted to. So I chose to leave so that I could pursue more freely both work that I'm here today to talk about as well as the research aspect. Wanted freedom to do both. And so you mentioned the American Federation of Firearms Toolmark Examiner, the AFTE, right? AFTE, yes. Okay. Are you active with AFTE? I'm just going to call it that because it's easier. Yes. So I am a distinguished member with AFTE. I'm also certified with them in firearm and toolmark identification, and I serve on the board of directors as well. And among other duties that I have, I'm also an assistant editor with our scientific journal. This guy's in the know about this path that he's chosen in life to pursue. He's in the know. He's got all the latest and greatest resources around him, you can tell. Okay, so is your association with AFD something that takes a lot of time because you're on the board? It does. In fact, I leave next week to go to a board meeting for that. Okay, and then in terms of outside work with other law enforcement agencies, tell the jury what you're doing and what you have done in the recent past that's relevant to this case. So, I have testified for both the state and the defense around the U.S. in very similar matters, whether it's a firearm identification type case like this or some other shooting reconstruction case. I also do civil work where I will represent firearms companies or the individual suing firearms companies due to the type of perceived negligence or a dropped fire or things like that. Okay, do you also do training in the area of firearms identification? Yes, I do. So I both take continuing education training. So I've received training over the years from the alphabet soup of government agencies. And then I also provide training to other law enforcement agencies. When I was in graduate school, I participated with Vanderbilt's Center for Teaching in a mentor that just reminded me of Zoolander with the school for kids who can't read good and other things. Sorry, the school. Okay, back to it. When I was in graduate school, I participated with Vanderbilt Center for Teaching in a mentorship program where I mentored undergraduates and taught them research design and, how to properly perform scientific research. And that kind of carried over again, just like the research aspect. The mentoring aspect really inspires me, and that's something that I enjoy doing. So I am contracted to train other crime laboratories, both in all these different areas that I'm talking about, putting on workshops that I'm an expert in, as well as training new examiners. So when they hire new people to come in, again, going back to the concept of our focus, when you're at the crime laboratory, is usually getting cases out the door. They don't have time to take individuals off of that casework to have them train the new people. So a lot of times they will hire in outsourced contractors like myself, and then I will basically, during that, across the 2 year period, train their examiners and get them competent in doing the same type of work. Are you doing that for other countries at the moment? Yes, I am. Wow. What country are you working on right now? So I just arrived back from Morocco a couple of weeks ago, where we have a strategic relationship with them through our military and the State Department. And so I was abroad. They have 5 new firearms examiners to help get them trained and also prepare them for their assessment so that they can be accredited. May I approach, Judge? Says Mr. Rosie. The court says you may. I'm slightly unprepared here. I'll hand you NNN, Exhibit NNN, let you take a look at that. Let me know when you've looked at that. Okay, I've looked at it. What is that? That appears to be a 6-page true and accurate copy of my resume, his CV resume. Okay, all right, your resume, right? A fancy word for resume, yes. I'm going to move to admit NNN, and I'm also going to ask to publish, assuming it's admitted later. I thought I had copies of this. Mr. Luttrell says, just one moment. No objection. The court says, all right, without objection, NNN is admitted. Mr. Rosie says, may I continue? The court says, you may. Dr. Warren, I used the phrase critical community in the past in talking with you. Do you recognize that phrase? Yes, I do. Okay, tell a jury. Let me ask you this simply. Is there a critical community, so to speak, in your industry as it relates to the legitimacy of firearms identification? Yes, there is. So, the critical community, as we've discussed, is generally professionals that aren't necessarily firearm and tool marks examiners, but are in some type of related or adjacent field. So, that could be engineering, mechanical engineering, it could be psychology or human factors, these types of things. And there are individuals, again, professionals in those areas that have certain opinions that are critical of the firearm examiner and our ability as a professional to do what we claim we can do. Okay. And is that something you've been dealing with throughout your time in this industry? Yes, it is. And in fact, I have testified on a couple of occasions in hearings defending the science and defending our processes and procedures for what firearms and tool mark examiners can do against those individuals. All right. Do you know what PCAST is? Yes, I'm familiar with that. Uh, what that organization is? Yes, I'm familiar with that. Okay, and the NAS, is that right? Or the NSA? The NAS, the National Academy of Sciences, yes. Are those two organizations that have been critical for the firearms identification business at times? I talk about this too in my Debunked and Dissected series. So we also do a firearms tool marking episode, and we debunk the Delphi bullet basically in that episode, and we talk about all these things, the PCAS, the NAS, and the uh AF, AFD or whatever I was saying it is. um are those two organizations that have been critical for your firearms identification business at times? So they are two groups or organizations they will contract a number of professionals in the legal field and the statistics field. Again, this critical community of people. And they have them review very critically, not to overuse the word, basically our publications and our research, and then form opinions on what the review reveals to them. What does PCAST stand for? So PCAST is the President's Council of Advisors on Science and Technology. Okay, and is that like the President of the United States that we're talking about? Yes, it is. It came out in 2016 and was for President Obama at the time. In your time as an FD board member, have you found that the critical community to actually be helpful in advancing? Have you found that this critical community is actually helpful in advancing the firearms industry? Yes. So whenever you have a constructive dialogue play out and you can discuss these things, it's essentially what's called peer review. So you have a situation where experts have a scientific discussion. They can bring, different perspectives into play and to be able to discuss those opinions on both sides. And it generally will push any scientific endeavor, but in this case, specifically forensics and firearm and tool mark identification forward as a field because we are able to take what those critiques that are being leveraged and design research to address those types of questions to essentially improve our field and to prove that we can do what we say we do. Did I, in the course of this case, ask you to review some material specifically regarding this matter? Yes, you did. And just tell the jury to the best of your recollection, what is it that you would have reviewed? So I was basically asked to review the examiner for the state crime lab, so ISP, Indiana State Police. That was Ms. Oberg, to review her work product, to review her conclusions that were expressed in her report, and to determine if the documentation, and essentially to evaluate whether the basis of her opinion was properly and sufficiently documented. And so, to accomplish that, I needed to review her case file, and I actually had 3 different reports and associated case files that I reviewed for this case, as well as the microphotographics, so photographs that were taken on the microscope, where she was comparing 2 different items together at the same time. It included other types of supporting documentation, such as I reviewed a transcript from a deposition that she gave earlier this year. Okay. Was the information that you received from me, in your opinion, was that adequate enough, or was it enough information to generate some opinions? Yes, everything that I asked for to be able to review, I was provided. Okay. Is there anything that you didn't get that you would normally suspect to be present in a case like this? No, nothing that comes to mind right now. Okay. And you mentioned that Mr. Rosie says, Judge, may I approach up here to grab a couple exhibits? Yes, of course, says the court. Mr. Rosie says, thank you. Dr. Warren, you mentioned that you reviewed some photographs, the micro photographs or microscopic. Is that fair? Yes, microphotographs or microscopic photographs, either would be fine. And are those the things that you would normally see in a case file in a situation like this? Yes, they would be. Okay, tell the jury from a procedural standpoint what the significance of is, or the purpose of, for those photographs when you do these, when you as a firearm examiner, when you engage in this process. Sure. So, photographs are one aspect of documentation. Documentation is very important for multiple reasons. First of all, the examiner, it may be years between when I worked the evidence or when an examiner works the evidence and when the trial goes, when the case goes to trial, if it goes. And so, the first aspect of documentation is to refresh my recollection when I'm told, hey, this is going to trial, you need to be at such and such location on a particular date. Another aspect of it is for laboratory accreditation. So there are requirements for the work process and product to be properly documented, such that another qualified examiner could review your documentation and understand and be able to determine why you reached the conclusions that you reached. And then I would say probably the most important part is to be able to illustrate to other people, such as yourselves, especially or specifically, what was observed. So, just like on a math test where you have to show your work, you can't just put down an answer and say, trust me, I got this the correct way. You have to show what you did and what your process was and what you actually observed on the microscope that led you to form those particular conclusions. There was some testimony in the courtroom earlier about this is like a movie when you review it. Are you generally familiar with that concept in your business? Yes. So generally the way I hear it is people say it's the photograph is 2D representation of what I saw in 3 dimensions. That's not correct. Actually, calling it a movie is slightly more correct. A microscope generally has a very narrow depth of field, which means you're getting a projection a from the light of a very, very thin slice of whatever is in focus underneath the microscope. And so, as an examiner is looking at it, they are constantly seeing that 2 dimensional image being projected into their eyes. And so, in a movie situation, you can move the bullet or cartridge case under the microscope and see multiple surfaces, multiple areas, or focus throughout the course of your examination. But generally, so documentation through photography has been very, very well accepted within our field since the 19th century. The importance of it has been recognized not only to, again, show your work and refresh my recollection of what I observed at the time, let's say 2 years ago, but also to be able to show others, hey, here's the proof. This is what I did. This is what I observed. And these are the reasons that back up my conclusions. All the way up to the 60s, all of them talk about the importance of photography and documentation for this very reason. So I would not want to discount it and say, oh, it's just a movie. I have all the time that I need when I'm examining evidence to get the lighting just right, the angles just right, the focus just right to take the best photograph that is representative of what I observed at the time that I did the examination. That was a very long answer. Guy is long-winded. I don't like it. To read it. Thank you for that. Are you familiar with the phrase subclass? Yes, I'm familiar with that. Okay, just briefly, in layman's terms, tell the jury, well, let me ask you, is the identification of subclass characteristics important in your business? Yes, it's very important. Okay, tell the jury what that means, just because it's been some time since we heard this. Okay, Mr. Luttrell says, "Excuse me, Your Honor, I don't know what that is." Okay, the subclass, what subclass means. Mr. Luttrell says, "Thank you, because it's been some time, thank you." So briefly, before I get into subclass, there's essentially three types of characteristics that examiners look at. So if you think about kind of an inverted pyramid, the top of your food pyramid, so you've got the top, the big level. This is like class characteristics. Class characteristics are going to be features that are common to multiple different firearms, just like for vehicles. If I said an SUV, that's a class characteristic. There are going to be a lot of different make model SUVs. It doesn't really give you a specific idea of something in particular. It gives you a general idea of what you're looking for. It may help you narrow down the pool of possibilities. On the very, very tip of that pyramid, you have what are called individual characteristics. These are fine microscopic scratches. We call them striations that are generally found to be individual or unique to a specific firearm, which I also debunked that. That's not, I don't know how we can determine that to be necessarily true. But that is a highly debated topic in the firearm and toolmarks expert world. In between there, you have what are called subclass characteristics. So these are features that are generally more gross. And when I say gross, I mean larger than the individual characteristics, and they help you reduce the pool of possibilities more than the class characteristics. But they can point to a specific one tool the way individual characteristics can. And so, an example of a class characteristic that's not firearms related, if you've got like a buck pocket knife and you're whittling some wood or something, you use it to pry open or you use it as a screwdriver because you don't have one on you at the time, and you cause that blade to chip or get some type of damage. Well, anything that you were to cut with the knife blade after you would show this gross feature in the cut on wood or wax or whatever it might be. And so that would be a subclass characteristic that would happen when firearms are being manufactured. The tool itself that is cutting the firearm or shaping it may get a particular chip in it, and the technician that is operating that machine doesn't realize that the blade had some damage to it. And so there'll be these scratches across multiple different firearms and were made that were made. So there will be scratches across multiple different firearms that were made before the shift changed and the tool damage was recognized and then changed out. So like a whole run of bullets might have this particular defect in it, is what he's saying. So that's like that's not an individual subclass. That's like a um more high level subclass. Speaking of, you promoted my memory, or you prompted my memory. Did I show you a copy of a quick, like a 5-minute video of a 6-hour plant where yes, guns were being manufactured? Yes, I saw two videos to that extent. What's the relevance of that video, if any, to this particular examination and the circumstances in this case? So I didn't see any relevance between either of the videos, neither discussed the specific tooling for the tools or the tool marks that were left on the cartridge, in this particular case. Okay. In fact, was there a spot in one of the videos where they said, "Hey, we can't talk about the details"? Do you recall that? Yes. So the videos were focused on the two major components that were manufactured: the slide, the upper part of the firearm, and the frame, the part that has the grip and the serial number. Whenever it would go to the details for the internal components, which would be things like the extractor and the ejector, that would be pertinent to this case. Those items were not mentioned. Okay. Because are these trade secrets and all that kind of stuff, right? That's one reason, yes. Okay. Have there been recent circumstances where laboratories have been shut down because of this inability to distinguish between subclass and individual characteristics? Unfortunately, yes. Okay, tell the jury when the last time you were aware of that happening in this country. Most recently, the Rhode Island State Crime Laboratory had to suspend its firearm and tool marks operations in part because of some issues with recognizing subclass. And then just before that, just a couple of months before that, the Wyoming State Crime Laboratory also had to suspend its operations. So you're not properly vetting these people, you're not properly making sure that they're using the right subclass characteristics, and as a result, your lab gets shut down for your state. I wonder how long they were shut down for. That's pretty crazy. When was the Rhode Island one generally, if you know? I want to say it was maybe, so first hit the news maybe a month and a half ago, but it happened, I want to say 2 or 3 months ago. Okay, so this is all very recent. Yes, it is. Okay. Let's talk about cycled rounds versus fired rounds, okay? Okay. Are you familiar with the distinction and the significance of what is in this case? Yes, I am. And tell the jury, can you explain to them what your knowledge of that is so that we're all on the same page? So when we talk about an unfired cartridge that has been cycled, that's specifically going to be in a semi-automatic firearm, so not a revolver. A semi-automatic firearm has multiple tools that, if it were to be fired, would extract the just fired cartridge case or brass out of the chamber and eject it so that the next live round can be automatically loaded. The trigger can be reset, pulled, and the whole process can repeat. If the firearm is not fired and one of those cartridges, so the live rounds, is fed into the chamber, the operator does not need to pull the trigger to shoot the firearm. Instead, they can decide not to, and if you remove the magazine and pull the slide back, that extraction and ejection will still happen to clear the unfired round out of the gun to make it safe. The process of that may leave some of those tool marks from the action of the extractor and ejector on that cartridge, even though it has not been fired, and that would be separate from a cartridge case, which is the same brass piece, but after it's been fired and that once live round has been disassembled through the firing process. And when a cartridge case has been fired, it's experiencing a lot higher pressure and forces in the interaction between the extractor and the ejector on that cartridge case because you've essentially just had an explosive reaction happen inside of that firearm. He's long winded. Okay. And so, in this case specifically, are you generally familiar with item 16? Yes, I am. Okay, and do you know that item to be an unfired cartridge case or a cycled unfired round that was collected at the scene of where the girls were found? Yes, that is what I'm familiar with. All right. And are you familiar with several firearms that were collected in this case by law enforcement and taken to the lab? Yes, I am familiar with several firearms that were collected and taken to the legal crime laboratory for processing and comparison. Okay. And specifically, is one of those what is now numbered item 315, or at least is it in the reports, which is a Sig Sauer handgun? Yes, that's correct. Okay. If I told you that that's the handgun that was taken from Mr. Allen's house, do you know that? I do not know that. I was not there when it was collected, but that is my understanding is that the ISP item 315 was the firearm that was collected from Mr. Allen. Okay. Mr. Luttrell says, "Excuse me, Your Honor, I think he misspoke. 315, I assume it wasn't intentional. 314." Mr. Rosie says, 314. I'm sorry. That's fine. 314. Yeah, 315 is the test fire. Sorry about that. Mr. Luttrell says 315 is not the test fires. Mr. Rosie says, "Gee, sorry, Jim. It's one of the closest rounds. That's right. Sorry. Thank you." Luttrell says, Mr. Rosie says, "Winchester." Luttrell says, "Memory box round. Yes, the Winchester." "May I continue?" says Mr. Rosie. "The court says you may. Thanks for that clarification." So, well, I've lost my train of thought. Oh, getting back to this distinction between cycled and fired rounds, okay? Is it appropriate in the toolmark to the firearm identification business to to ex, to examine a cycled round with a test fired round? In other words, kind of comparing the two differences. Is that an appropriate process? It is a process that is done. It really depends on I guess, what the question that is needed is to be answered is. So generally, due to those differences in pressure of a fired versus an unfired cartridge, a fired cartridge case versus an unfired cartridge, I'm sorry, you've got those differences in pressures. You've also got a difference in the amount of time with which those tools are in contact with that item. So generally, I would expect to see what I would say apples to apples, not apples to oranges. So if you're looking at the mimicking the tool mark on on that unfired cartridge, I would want to compare that to another unfired cycled cartridge. So there's been research, I want to say, starting back in 2010, the University of Ames in Iowa started doing some research looking at the effect of the angle and the pressure of tool marks and the types of markings that they have. And that research was continued in 2014 by NIST, which is the National Institute of Standards and Technology. And it's been performed by other people, even in the Netherlands. But even just a 15-degree difference in a tool mark can change the appearance of the tool mark. So if they made a tool mark at one angle and then changed the angle by just 15 degrees and made another tool mark, you couldn't identify the two as coming from the same source. Similarly, they found that differences in pressure can change the type of markings that are left by a tool. And so when you're thinking about it, you want to compare apples to apples. That's why crime laboratories, including my lab, we have a large reference collection of ammunition, a reference collection of different firearms, because you want to be able to make sure that you get the closest thing that you can to find the evidence that you have in front of you that you're examining. In this case, Ms. Oberg was unable, are you aware that she was unable to cycle a dummy round and create marks that were sufficient enough to compare to item 16? So she did. Mr. Luttrell says, "Objection, Your Honor. I don't believe that. I think he misstated the evidence. That's not what she testified to." Sustained. Mr. Luttrell says, "She testified that she used both the test fired and the cycled rounds and did acknowledge that the test fires were more prominent than the cycled rounds, but that she used both." Really? More prominent? You mean they existed versus they were non-existent? Because if that's what you mean, then maybe. Mr. Rosie says, "May I ask the sustained?" Yeah. "Did you review her report?" I did review her report and her case files. Did she use the cycled test round to draw her conclusions about item 16 in the gun? No. So the notes indicate that her notes indicate when she compared test fires from Mr. Allen's firearm to the cartridge in item 16 that it wasn't dummy rounds, but they were live rounds from the reference collection that when those were hand cycled, the marks that were on them weren't prominent if they were reproduced at all. So they were not prominent if they were even reproduced at all. Also, in order to effect a final conclusion, the majority of what was relied on for that opinion were the fired cartridge cases from that firearm. Okay. And you are generally okay with that process, the idea that you're taking a fired cartridge case and extrapolating? No. So the AFD, generally accepted in the field and expressed in AFD, as well as the ISP protocols, are that in order to form an identification, you have to first prove to the tool marks, you have to first prove that the tool marks are both repeatable and reproducible. Aren't those the same things? We spoke of some of the other guns. There was one firearm in particular, I think it was item 101, where the discussion in the notes was very clear that the markings were both repeatable and reproducible across both the fired and the unfired cartridges. So I'm going to clarify both the fired cartridge cases and the unfired cartridges. In this particular case with item 315, that was not the case. So the reproducibility and the repeatability for that apples to apple comparison had not been established, so that would not be something I would rely on. Are you familiar with the phrase error rates? Yes, I am. Okay, there's been some discussion about that in the courtroom, not today, but previously. Are there any error rate studies that are based on comparing a cycled unfired round with a fired round? No, there are not that I'm aware of. So there are not any error rate studies comparing cycled versus fired rounds because you just don't do it. I mean, you can for, like he said, for comparison, but you don't use the opposite for saying that that was how you got the marks. I don't know. It still doesn't make sense to me how she used a fired round and you're comparing it to an unspent round. Okay, let's get back to subclass and Ms. Oberg's findings. Okay. All right. We'll tell the jury, what are the three tools here that are really in play in her examination? So the three tool marks that are in play, to use your terms, are the extractor, the ejector, and the what she calls the chamber face. I generally call the barrel hood. Okay. Let's start with the ejector. What is your opinion about the possibility existence of subclass characteristics with the ejector? So the ejector is objection, Your Honor. If I may ask a preliminary question, you may, says the court. You indicated to the jury that you were familiar with item 16016, correct? Yes, that's correct. You never seen it before, though, have you? I have not seen any of the evidence in this case in person, no. And therefore, you really can't answer the question that was posed to you since you hadn't specifically seen or examined the evidence in question, correct? No, that would be incorrect. That's all I have, Your Honor. That was the dumbest, pointless, most pointless question ever. Okay. Mr. Rosie says, can I ask a couple of foundational questions to educate the jury? Sure. First of all, did you review Ms. Oberg's case file, the 14-page report that has all the details in it? Yes, I did. And did you look at the photos of item 16? I looked at the photos of item 16, that is correct. The microscopic photos. Both the microscopic photos taken with the regular, like, point and shoot camera, as well as the microscopic photographs as well. And in the course of your industry, your profession, is that adequate enough for you, in your opinion, to draw conclusions? For the conclusions I am drawing in this case, yes. Okay. So the question is, with the ejector, the first tool, what was your opinion about the possible existence of subclass characteristics? So Ms. Oberg, in her case file, documented the ejector quite well. She took photographs of it, the ejector directly, as well as the ejector marks that were left on the unfiltered cartridges and the fired cartridges, unfired and fired cartridges. When those were then compared to the cartridges in item 16, she also noted that the machining surface on the ejector had a high potential for subclass, and based on her photographs, I would agree with her. So, again, if you go back to subclass characteristics, typically when an item is molded, it's stamped or it's CNC machined. The CNC stands for computer numerically controlled. Essentially, it's a fancy way of saying you put it in a box and a computer controls all the machining operations. These have the highest propensity for leaving subclass marks. So you think about that chip in the knife blade, and you cannot rely on those for an identification, and that is something that in her documentation Ms. Oberg notes as well. Then with regard to the extractor mark, what did she document regarding the potential for subclass, and how well that was that documented? So there was no documentation of any evaluation for subclass in the extractor itself. Research, so there are probably in excess of 20 particles specifically relating to subclass on extractors, and the general consensus among these articles across different firearms, the types of machining that occur on extractors lend themselves to subclass marks. But again, there was no documentation of this type of research, and certainly no direct examination of the extractor itself like there was done with the ejector. And then with regard to the barrel hoods, same two questions. What did you find in terms of subclass documentation? And well, let me ask you that. So the barrel hood or chamber face, depending on which term you want to use, has even less research regarding it, because that's not a typical tool mark that is used. It's actually a tool mark that I've never heard of being used until this particular case. That's just not any research out. There's just not any research out there on it to determine specifically the types of machining operations that occur, whether there's a potential for subclass like there are for more common tools that are usually relied on, like the extractor and the ejector, or even the breech face and the firing pin impression. This guy is saying so many big words that I'm lost. I bet the jury's lost. He's such a talker. He needs to dumb it down, right? Like I'm losing interest in what he's saying because he's saying so much and I'm not understanding half of it. So just to kind of try to maybe summarize, is in your opinion, is there a potential for subclass characteristics with regard to all three of those tools in this case? Yes, there is certainly the potential for subclass on all three tools. So is it accurate to say then that you can't make any identification or any identifying specific identifying characteristics because of the potential for subclass? Objection, Your Honor. I'm sorry. Mr. Luttrell says, can I rephrase the question? Mr. Luttrell says, I'm sorry. Mr. Rosie says, can I rephrase the question then? Sure, says Luttrell. Mr. Rosie says, I think I agree with you. We're talking. So, is it possible, in your opinion, based on what you've seen from her work, to draw conclusions about individual characteristics in this case? So, no, you can't draw conclusions about individual characteristics unless you have done the appropriate research and determined what the differences are. So, she should be doing that with this this run of bullets. She should be looking at the what the differences between subclass and individual characteristics. Is she able to look at those or to be able to determine individual characteristics? He says no, based on she didn't do appropriate research or determine the differences. So which markings are individual and which ones are subclass? She was not able to determine the differences between individual and subclass because she didn't do the research involved. Once you have done that, if there are individual characteristics, once the subclass characteristics have kind of been subtracted from the equation, then you could make a conclusion regarding that. Okay. And was that done here? Only for the ejector. Okay, so may I approach, Your Honor? You may. Let me hand you what's been marked previously as Defendant's Exhibit 000. If you would take a look at this first, then before I ask you a question about it. All right, are you familiar with that, the exhibit? Yes, I am. Or that photograph. So I reviewed specifically for this report and the associated case documentation. I believe there were 13 or 14 photographs that I reviewed, and I recognized this as one of them. Okay, just tell the jury what that tool mark is that we're seeing, that triangular tool mark. Yes. So the triangular tool mark would be the ejector mark. So if you were looking zoomed out, the primer of the cartridge would be down here. The circular part with the firing pin strikes. Mr. Luttrell says, "May I, Your Honor, may I approach so I can see?" Yes, you may. Of what he's talking about, continues Luttrell. The witness continues. So the triangular portion would be the impression from that ejector as the cartridge is being drawn rearward under the pressure of pulling that slide back. I don't know. I don't know what that word is. Rearward? Rearward? Rearward. Rear. So towards the rear. That's what that is. Rearward. Okay. Let me start that over. So the triangular portion would be the impression from the ejector as the cartridge is being drawn rearward under the pressure of pulling that slide back, or the force of that slide being pulled back, and the ejector essentially a stationary pin. So that slide is being drawn back, the cartridge case is being pulled rearward with the extractor. That's really hard for me to say. It strikes that stationary ejector, which causes it to pivot and come out of the gun. And so what you're looking at is the impression that is left as the cartridge is being pulled rearward and striking the ejector. So just to orient the jury again, is this the hairline down the middle here that kind of separates the image on the right and the image on the left? Yes. So on a comparison microscope, we have what's called a dividing line, and that basically is what separates what is on the left portion of the microscope from what is on the right portion of the microscope. So generally, you'll see in photographs that whatever is being examined in that particular photograph will be lined up between the two slides right at that dividing line. All right. And so the right side of this line is labeled 314 T1. Is that correct? Yes. So what the labeling indicates is that on the right hand side of that black prism line, we are looking at test fire 1 from item 314, and on the left side, what you're looking at is item 16. Okay, so when I look at this, I mean, I'm seeing these lines that cross over the hairline that are in similar locations. Do you see those? I do see those. They're kind of lighter than the rest. Yes. Okay, tell the jury what that is. So what happens in these microphotographs, we use oblique lighting. So if this is the surface, the top surface of the cartridge, there is light up here, not directly shining at it 90 degrees, but it's shining obliquely coming at it. So what you see with the light areas, those are the mountains if you think of this surface of being a microscopic contour. The high area shows up as light, white areas between the light is coming in and striking those. The valleys are the dark areas in between, and if you look closer, you can also see some finer stuff, some finer striations They're just not quite as light because most of the light that is coming in is being obscured by a taller mountain peak, if you will. And so what is being illustrated here, subclass characteristics generally appear as, like I said earlier, gross marks or the larger marks, in this case, the brighter marks, and they also generally have a uniform spacing. So if you notice, the spacing between here and here is uniform. Both of these together are hallmark examples of what is subclass. And so if I were going to do this evaluation, I would essentially subtract out these lines and look for those finer striations in between that might be individual in nature. And when you do that, you notice that the one on the left doesn't have all of the same marks as the one on the right that I would expect if I was going to form an opinion that there were sufficient agreement of individual characteristics, which is the standard to affect an identification. So he just said a whole lot of stuff. But basically, he says, I would expect if I was going to form an opinion that there was sufficient agreement of characteristics that there would have been more marks. It left different marks. It's not the same. It doesn't have all the same marks on the right as the one on the left. When he's comparing them, he's saying that it's not sufficient enough to be categorized then, I guess, as an individual characteristic. So he does not think that the striations that she identified are sufficient enough to claim that it was a match. So even though these marks are very, very similar, these white marks, that could be from the same tool, same lot. It's subclass. So the potential for subclass is certainly reminiscent with these. Indicative of these are indicative of what I would expect to see for subclass. And it would be the other stuff in between, the other striations that would potentially be the individual characterizations. That was OO, Mr. Rosie? Yes, OO. Actually, it's triple O. Luttrell says, are you going to be showing other items like that? Mr. Rosie says, I'm not sure. I'm not sure. I'm trying to finish up here. So with the crime lab, yeah, like, dude, I'm in the middle of cross-examination. Can you not interrupt me? So with the crime labs that you talked about, like Rhode Island being recently shut down, is it accurate that you were having problems distinguishing between these grosser marks and the finer marks? So the report that was generated in that particular evaluation, Mr. Luttrell says, objection, Your Honor, I don't see how the Rhode Island event has anything to do with us here today. They brought it out. They've said it was a problem over subclass. Getting into the details of the Rhode Island event, which he has not been a part of, is irrelevant for this case. Mr. Rosie says, I think comparing Rhode Island circumstances and our circumstance has a tendency to prove that these circumstances here that you see with the naked eye can be deceptive. And these are Ms. Oberg's photos. The court says, which the ISP lab has not been discredited as the Rhode Island lab has. So I would sustain the objection on relevance. That's like she just makes up stuff out of thin air why she will object or why she will sustain an objection for the state. Mr. Rosie says, thank you. Well, strike that. Tell the jury, what CMS is. So CMS stands for consecutive matching striae or consecutive matching striations. And what is the relevance of CMS in your field? So we talked about those. The body of critical experts earlier. One of the critiques is that the standard currently, as it's written and accepted and practiced in the field, is that a particular examiner has to observe sufficient agreement of those individual characteristics. CMS is an attempt, again, to answer those critics to prove a threshold or a numerical objective value. So the research was first published in 1959 in California, and It has been continued to be expounded upon. Another landmark publication was in 1970, and it continues to be published in law books that are pertaining to the modern scientific evidence and what experts might testify to. And what that is it's a numerical criteria that says when you examine these types of striations in order to obtain a conclusion or to reach a conclusion of identification, you have to have either 2 runs of 3 consecutive striations or at least 1 run of 6 consecutive striations. Mr. Luttrell says, Your Honor, at this time, I would object and ask leave to ask a preliminary question. You may, says the court. Mr. Luttrell says, Dr. Warren, are you aware the Indiana State Police does not use CMS methodology? Yes, I am aware of that. So, see, you are aware that most laboratories do not use firearm, toolmark laboratories do not use CMS. So, you are aware of that, are you not? Can he answer the question? Says Mr. Rosie. The court says, well, it's a yes or no. Yes or no. Is he aware? So I am aware that there is a subset of crime laboratories that do not use this, but I need to clarify that CMS is not a different examination. The foundation of finding striations is the exact same, the difference in policy and methods. Mr. Luttrell says, Your Honor, that's not answering my question. Answer the question, sir, says the court. Wow. Mr. Luttrell says, Dr. Warren, the question is, most laboratories, firearm, tool mark examination do not use CMS criteria, correct? Can you guys hear him? He is having a nightmare and squealing in his sleep. Now he stopped. So again, as I testified, I would say I know that some do not. I do not know that I could qualify it as most. Mr. Luttrell says, and you do not, do you? No, sir, I do not use CMS. Mr. Luttrell says, and when have you been trained on CMS? I was invited by John Murdoch to California in the beginning. It was either the end of 2022 or the beginning of 2023. He invited me out to help him teach a course in California and be the guest out there. Mr. Luttrell says, I didn't see that on your CV, Mr. Warren. Yes, sir. I believe it's under the list of training. Mr. Luttrell says, I have no further questions at this time. Thank you. The court says, would counsel approach, please? Sidebar conducted. The court says, I'm sorry to interrupt, but something needs a break. Mr. Rosie says, I'm almost done. I'm in the last 3 or 4 questions. Mr. Luttrell says, and I apologize. I forgot. Apology accepted. Give me 5 minutes. I don't want to say I'm asking 3 questions and then I'm asking 4. All right, so 5 minutes. Mr. Rosie says, you may, I'm pretty much, okay, says the court. Sidebar over. Mr. Rosie says, oh, I'm sorry. Go ahead, says the court. Now, I'm trying to move on hastily. Is the CMS process, the subjective process, is that a process that AFD has adopted? I'm not sure if that's the right word, if they've adopted or they recognize maybe as a better word. Yes, so CMS is recognized by AFD. It is not addressed in the AFD theory of identification, and that's what I testified to earlier. The standard is just that there's sufficient agreement. CMS takes that one step further to try and set an objective criteria that since 1959 has been established. So it's kind of like a score sheet, right? It's supposed to take the subjectivity of all this out. It is minimizing the subjectivity, that is correct. All right. Has that been one of the biggest critiques on this discipline is that the examiner can have a different opinion than the next, subjectivity? Yes, that is one of the major critiques. So that I'll talk about that also in the Delphi debunked and dissected episode where we debunked this bullet. I talk about how it is subjective. You can get you can have 10 different examiners do the same exact examine the same exact tool marks and come up with 10 different opinions. So it's very subjective. You can't and you can't prove that these marks came from here. You really can't. So none of it is really proof of anything. Did you apply your own? Well, let me ask you this. Strike that. In terms of working through the CMS process, what information do you have to do that effectively? So with CMS, you generally take a photograph of what you see on the microscope, and then out next to it, you will tabulate individual striations that you observe to be in agreement and count the consecutiveness. Okay, and are the photographs the biggest part of that process, making sure that you have adequate photographs? Yes, that is a prerequisite for the method. Okay, and in this particular case, did you apply the CMS standards to what you saw in Ms. Oberg's work? Yes, sir, I did. So basically, you take the microscopic photos and then you can do this other method in order to basically count your matches, your striations that supposedly match. And he did this new or different kind of method with Ms. Oberg's photographs, her side-by-side photographs. And what were your findings based on your experience in that CMS process? So the extractor itself, I believe, had one run of 4, which does not meet that threshold. The barrel hood or chamber face, depending on the terminology, I did not find any consecutive runs. They really should have explained these parts of the gun that he's talking about before they just went into whatever. I found multiple runs of 1, and the ejector, if you ignore or subtract out of the potential for subclass again, I did not find any consecutiveness. So would you, based on that objective score sheet, would you have drawn a conclusion that there was sufficient agreement or insufficient agreement? No, so there would be insufficient agreement. I don't have any other questions. So he's saying these bullets don't match. But he didn't really get into, like, I'm kind of disappointed in this testimony. This guy had like great a great background, and then you get him to talk and you can't understand what he's talking about. They don't really go into the whole apples to oranges very much about how it's fired versus unfired. I mean, they talked about it some, but not really. Why that's an incorrect way to compare to do fire tool firearm tool analysis. It's not the right way, obviously. By firing one and using an unfired bullet and comparing them, it's obviously you have to have the same product at the end, right? I would think. Anyways, so the court says, all right, ladies and gentlemen, we're going to take a quick break, give you an opportunity to get up and move around. While you're outside the courtroom, please keep your minds open. Please don't form any opinions or conclusions about anything. You may discuss the evidence, but please only do that if all 15 of you are present in the jury room at the same time, and please don't deliberate. Gentlemen, all rise. The jury leaves. The court says, all right, let's take 15 minutes and go off the record. And that's where we're going to end today. We will begin when they come back on the record. And like I said, we are going to be going over Dr. Eric Warren's cross examination and redirect and all of that, and jury questions. And then um, we're going to have direct examination of Stacy Eldridge. So, Stacy Eldridge is a data forensics expert. So she's going to look at the phones in this case. Maybe she found something on Libby's phone. I mean, it's not a spoiler if you guys had followed the case before, but maybe she found something on Libby's phone that tells us maybe something about the state's case is inconsistent. So that's who we will have next. And then, like I said, we're almost done. We have one more PDF file, and then and that includes like the last examination, the last defense examination. Then we've got 2 rebuttals, like I said. Then we'll have closing and jury instructions, all of that, and then we'll do a separate one for sentencing, I think. Or maybe we'll try to get that all in one. That might be a longer one. So that's what I have for you. So thank you guys for sticking with me with this. I think it's fun to read through these kind of to see where the judge is like, you can't say that. And it really could affect the outcome of, like, judges have so much power. Judges are supposed to be the, unbiased, like, basically like a teacher. They're supposed to be like, you stay in your lane, you stay in your lane, don't fight with one another, and, tell me your, what, tell me your homework, basically. Uh, and let's not fight with one another. They're supposed to do that, right? They're supposed to keep the peace and all that. Well, it seems like one or two really important rulings, like having a mental health expert not be able to talk about Richard Allen's mental health at the time. I think that's insane. That's wild. You hire a mental health professional to come in and he can't even talk about the witness, or I'm sorry, the defendant that he's supposed to be talking about, the defendant whose file he analyzed and looked at. Why is that? Why can't he talk about it? Why can't the jury know certain things? It's very scary to me how powerful judges are with a couple of sustains here, a couple of overruled there, and the state could basically get their whole case, everything that they want for the most part. And a defendant can really be screwed if the judge is a certain way. And we see it in Judge Gull's, in this case, Judge Gull. We saw it with Bev Canoni. We see it in several cases now when we're really looking for it and we can find it. It's um Judge Elmore from the Aaron Spencer case. There's another one who was overusing her power. So it happens everywhere. The Arkansas Supreme Court actually threw her off the case because she was overusing her power, overreaching. But yet nothing happens to these people. The judges continually go on and commit the same types of acts on innocent people. Or maybe they're not so innocent and they think that it's their job to determine that they're not innocent and punish them like Judge Gold did before Richard Allen ever even had a trial. So I say we get rid of qualified immunity. It needs to go away so we can hold these people accountable. That's my message for the day, and I'll leave you guys at that. Thank you so much for watching. Let me know what you think, why these experts can't even talk about the defendant that hired them to talk about him. It just doesn't make any sense. Why all these things are so limited. And be or stay tuned also for, we're going to read through the so he's an appellate now. He's appealing his case, and he's filed his his original filing for appeal, and then the state has replied, and now he's responded to the state. So we're gonna read through all of his reply in a corruption files update, or two. It might be 2 episodes, but we're gonna try to get through it. So stay tuned for that, because we're going to go through arguments of what was wrong with this trial and some of the errors that the court made. So we'll talk about that in the upcoming corruption files update, where we'll talk about the reply brief from Richard Allen. So thank you guys so much again, and I will see you in the next one. Stay tuned. Bye. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.